Okay, well, it's 2 minutes past 10, and I'm going to make a start. Welcome, everybody. Thank you so much for logging in this very cold and frosty December morning at 9 a.m. In order to listen to this webinar. For those of you who don't know me, my name is Holly Doyle. I'm a barrister at Guildhall Chambers, and I've been here since 2008 when I did my pupillage with Hugh Sims QC, who's the head of our commercial team. I practice in commercial and insolvency law. And I'm delighted to be able to welcome my co-speaker this morning, Rachel Lay of Menzies LLP, licensed IP and director of Menzies. We started at around the same time. So I think it was 13 years ago, Rachel, wasn't it, at Harris Littman? And then that merged to become Menzies in 2015. So we're peers, as it were. And we're delighted to welcome you all this morning. Just as a matter of housekeeping, this session is being recorded so that it can then be put up on our website and distributed amongst the delegates. And you can then pass it around within your firms to anybody else who might be interested in watching it. And if you've got any questions in relation to the talk this morning, we'd be grateful if you could save them until the end and also use the chat function in order to put them. But otherwise, if you could keep your microphones on mute, that would be really helpful. Thank you. We're talking this morning about the standard of care for insolvency practitioners. It's a subject which is very dear to all of our hearts as either lawyers or IPs in this field. And it's something that we think doesn't get a lot of love or care as a standalone topic. It tends to be subsumed into talks about duty or talks about breach. So we're going to give it a bit of love this morning and focus on it. The context for giving this talk is the fact that Rachel and I are two of the authors involved in a book that's being published, I think this week, by Algar Publishing on insolvency practitioners. And that covers appointments, duties, powers and liability. And in fact, it's got quite a detailed section about formulating claims in relation to IPs and also defending claims. So covering both bases. I have put that slide there as a shameless plug for this book, and there's also a little link which you can go to have a look at the website, which contains a lot of quite nice words and endorsements from people that have read it already. And with that in mind, and because we don't want to breach any copyright laws, we're not going to be producing a paper for this talk, but we will be circulating the slides afterwards. And of course, you can also rewatch it again should you want to, because there'll be a recording which will be on the Guildhall Chambers website. So without further ado, if we move on to the agenda for this morning, I'm going to be talking generally about the standard of care, and then I'm going to go on to speak a bit about the role of expert evidence in determining the standard of care. And then we're going to go on in the third section to talk about some actual specific applications of the standard of care in different areas of the daily diet of an IP's life. So focusing on advice, investigations, pre-packs, other asset sales, and then finally commencing and conducting litigation. So the duties that IPs have to comply with obviously stem from a number of sources. The most important is probably statute and regulation, and that's principally the Insolvency Act and the rules. But there's also common law in respect of any tortious duties of care that are assumed, and potentially also contracts, because of course IPs may take on contractual duties in respect of the provision of advice pre-appointment, for instance. There's also equitable duties, because IPs are subject to fiduciary duties stemming from their position either as trustees in bankruptcy or as agents with custody and control of company assets. The standards that apply to a fiduciary where there's no negligence overlap are really outside the scope of today's talk, but we might touch upon it a little later on. In carrying out at least their statutory duties, it might be said there are two different standards that are applied to IPs, and I've tried to characterise this two-tier system as strategy and commercial decisions versus implementation or action. So there's a critical difference between challenges to the commercial decisions adopted by an IP, where they have discretion about how to proceed, and then second, what might be described as challenges to the way that their chosen strategy has actually been implemented, or challenges in circumstances where there's no discretion. As to the first category or tier, although every form of insolvency process is under the supervision of the court, the court won't generally interfere with the IP's exercise of their discretion in the conduct of their office, because that's explicitly delegated by statute, and that's section 1684 in the liquidations context and section 3052 of the Insolvency Act in the bankruptcy context. An early clear statement of this understanding is the bankruptcy case ex parte detriment Doyle, which is the first one on the slide there for you. And really, this delegation is the result of both protection that's already afforded to stakeholders in the insolvency process. So we were talking about Doyle and saying that the delegation that the courts allow is a result of both the protection already afforded to stakeholders in the insolvency process by the fact that all IPs have to be licensed, and also the general reluctance of the court to intrude into what are essentially decisions made by commercial actors. So you see the same sort of reluctance at play manifesting itself in the court's refusal to rewrite contracts for commercial parties. The exercise of the IP's powers are therefore almost always going to be by reference to what the IP and not what the court thinks will be in the best interest of the insolvency process. And so the stance routinely taken by the court in these sorts of matters is one of deference, unless the conduct of the IP is unreasonable, and that's Pittman and Top Business Systems, or absurd, and that's Leon and Euchematic. A really good clear statement of the stance taken by the court is going to be found in the bankruptcy case of Osborne and Cole, and that was then Registrar Baster, who held that the test is whether the trustee has acted in bad faith or so perversely that no trustee properly advised or properly instructing himself could have so acted. Alternatively, if he'd acted fraudulently or in a manner so unreasonable and absurd that no reasonable person would have acted that way. In the administration context particularly, we know this is in keeping with the intention behind the legislative history, because if you have a look at Hansard, you'll see that Parliament expressly wanted administrators' decisions to be subject to the sort of rationality test that we see in public law with the Wensbury unreasonableness test. As to the second category, or the second tier, which is the implementation or action stage, a good example of the distinction between these two categories is found in the well-known receivers case of Medforth and Blake, which is at the bottom of the slide there. In that case, a claim was made by the company against appointed receivers for failure to run their pig farming business efficiently, because they didn't maximise returns by securing substantial discounts on the supply of foodstuffs for the pigs for the purpose of carrying on the business. And it was essentially trite law in that case that the receivers, when they were appointed, weren't obliged to carry on the business. It was in their discretion as to how to realise the asset. But if they chose to carry on the business, they then held a duty was owed to manage it with due diligence. So there's a duty of care over and above the duty of good faith, and the standard was the standard to be expected of a reasonably competent receiver. So that illustrates the distinction between matters of discretion and then implementing discretion, where duty of reasonable skill and care is owed. The requisite standard of care was described in relation to administrators by Mr. Justice Millett in Charnley Davis as essentially being the fact that an administrator is a professional insolvency practitioner. A complaint in relation to breach, in that case, failure to take reasonable care in the sale of company's assets, is therefore a complaint of professional negligence. And so the law in relation to professional negligence applies. And so it follows that an administrator is to be judged not by the standards of the most meticulous and conscientious member of his profession, but by those of an ordinary and skilled practitioner. So in order to succeed in a negligence claim, the claimant has to establish that the administrator made an error which a reasonably skilled and careful insolvency practitioner wouldn't have made. Now, we know that this test also applies to liquidators in exactly the same way, because that's paragraph 28 of the Mama Miller case there at the bottom of the slide. And it's likely also, in fact, it's assumed to apply in the bankruptcy context too, since the language of section 304 mirrors that of section 212, which is the misfeasance provision in the Act. How do you determine whether an error has been made? Well, first of all, you look at the reasonable IP. That's an objective standard. It means an ordinary skilled practitioner, and that means that no allowances are made for a lack of seniority. And that is the general negligence case of Nettleton and Weston is the authority for that proposition. The test that is applied is the well-known Boland test, which is named after the medical negligence case on the slide there, but applied to all professionals. And in essence, The test means that a professional person isn't guilty of negligence if he's acted in accordance with a practice accepted as proper by a responsible body of people skilled in that particular art. So, in other words, an IP can demonstrate if a responsible body of opinion in the same field would have acted in the same way, then no liability should attach for the purposes of the law of negligence, and the IP will have discharged their duty. You might be forgiven for thinking in those circumstances that any IP who were to find their actions challenged would need only to find another independent IP who would be prepared to endorse that conduct under challenge as being reasonable. And it's true that too often we do see expert evidence both for claimants and for defendants that simply indicates what the expert themselves would have done in the same situation. That isn't the test. It's not about what another individual practitioner would have done in the same circumstances, but whether the act or the omission that's impugned was in accordance with a practice accepted as proper by a responsible body of the profession. Now, it has to be a responsible body of opinion, and the standard is that which, in the opinion of court, members of the profession ought to achieve, and not that which members of the particular profession do in fact achieve ordinarily. So evidence as to the general and approved practice is of very considerable importance, but it's not automatically conclusive in every case. It could be that the profession as a whole has become a bit lax and allowed an unreasonable practice to slip in. In judging the reasonable standard, the courts will take very particular heed of any codes of practice and other guidelines that specify what professionals must do in particular situations. And of course, there's a wealth of this sort of guidance available for IPs. In addition to the recently updated Code of Ethics, we've got of particular relevance statements of insolvency practice. Of these, probably SIP 13, which is the disposal of assets to connected parties, and SIP 16 on pre-packs are the most commonly encountered in this context. Obviously, a failure to appreciate the applicability or have regard to either of those SIPs are going to be strong indicators of a failure to act with due care and skill. But even the Dear IP newsletters that are circulated by the Insolvency Service may contain guidance which can be and is used as evidence of common or competent practice. And an example of that is the Saphir and Wardell case there, where the issue at hand was whether the Secretary of State fee was to apply to sums paid into the Insolvency Service's account, and the Dear IP newsletter was relied on for common or competent practice in that regard. The skill and care required must also be interpreted in the light of the availability of advice and guidance for an IP. And there's a very old case on the slide there called Rehome and Colonial Insurance Company, the decision of Mr. Justice Morn. And he said famously, in a much quoted passage, that a high standard of care and diligence is required from a liquidator in a voluntary winding up. He is, of course, paid for his services. He is able to obtain, whenever it is expedient, the assistance of solicitors and counsel, and, which is the most important consideration, he is entitled in every case of serious doubt or difficulty in relation to the performance of his statutory duties to submit the matter to court and obtain guidance. In that case, the liquidator had admitted a claim which was founded on a contract for the reinsurance of marine risks in circumstances where rejection of that claim would actually have left the company completely solvent. After dissolution, it became apparent that in fact the reinsurance contract was unenforceable and the company was restored for the purpose of bringing proceedings against the liquidator. Mr. Justice Morn noted the ability of the liquidator to obtain legal advice and the ability to obtain direction from the court, and found that the liquidator was in breach because he had chosen to navigate these narrow seas, to him unaccustomed and unknown, without either chart or pilot, and for this temerarious conduct he must bear responsibility. I think Justice must be much more fun in the 1930s. Certainly much more eloquent. Thus, IPs are expected to engage and rely on the services of independent professionals, including lawyers and counsel, obviously, estate agents, valuers, and other professionals to assist them in discharging their duties. So an example of that would be an obvious example, a failure to properly ascertain the value of a company's assets by failing to obtain a proper valuation from a proper valuer will likely constitute a failure to exercise reasonable care and skill, which might give rise to a claim in relation to sale and undervalue. A recent illustration of that principle is Brewer and Iqbal, which is the middle case on the slide there. In that case, Chief ICC Judge Briggs held that the administrator had placed too much reliance on the directors of the company to provide a value for the assets, which were EPGs, which were intangible assets. And they were a class of asset with what was described as being a restrictive but competitive market. but there were specialist EPG acquisition and sales agents. And the IP should have known about this and should have acted on it and instructed one of those agents to value the company rather than a general machinery agent. So by not taking that sort of advice, the IP obviously ran the risk that the sale would be for an undervalue. IPs are also very likely to obtain appropriate advice, and especially legal advice, prior to commencing litigation and entering into compromises, as well as in relation to asset sales. And to a certain extent, this becomes a self-fulfilling prophecy, because the done thing then becomes the expected thing. And legal advice on litigational settlement has almost come to be expected by the court now. And there's a statement of that principle in the Australian case at the bottom of the slide there, page 483. As well as cases where IPs have been castigated for not taking advice, there's obviously a flip side, which means that there are various cases, including Davey and Money, that suggest that an IP who does take proper and apparently competent advice and then acts on it in good faith, provided that it's within the scope of his or her powers, is generally not open to challenge, even if the advice relied on turns out to be wrong, provided, of course, it wasn't wrong because of any fault on the part of the IP, such as erroneous or incomplete instructions, which we'll come on to later. The added bonus is that the costs of obtaining advice are almost always going to rank as an expense of the insolvency process and usually get paid out of the assets of the company. So the upshot is there's every reason really for an IP to seek professional advice, although obviously that general principle is going to be subject to the fact that funds and or time might be too short to obtain advice in any particular case, and each allegation of failure to meet the required standard of care is going to be judged on its own facts for those reasons. The time that an IP's conduct is to be assessed is at the time of the act or the omission complained of. And similarly, the standard against which an IP's conduct and acts are assessed is the standard which prevailed at the time of the relevant conduct, and not at the time, no doubt, many years down the line where the matter comes up for the court's assessment. And that was made clear in Pitt and Mond, which is the middle claim on the slide there. It would be remiss to have a talk about IP standard of care without mentioning the fact that we still have the rule in Ex parte James, requiring that in rare circumstances IP shouldn't rely on their strict legal rights. The formulation which is most often, I think, is wherever the enforcement of that legal right would, in the opinion of the court, be contrary to natural justice. And that's Mr. Justice Salter. The rule is of some antiquity, but it appears to be entrenched. And in fact, if you want a recent treatment of it, have a look at the Lehman Brothers Australia and McNamara case at the bottom of the slide there. And you can see how it's being treated in the modern world. Another interesting and fruitful area relates to delegation and control of cases, which I'm going to hand over to Rachel to look at.
Thanks, Holly. So IPs frequently work as part of a firm, and when they do, they might delegate work to others within their firm. In particular, work's often delegated to more junior members of staff, as this allows an IP to handle a higher caseload. In some firms, there's a management structure where IPs delegate to managers, and then managers delegate to and are responsible for junior staff. Work may also be delegated to specialists within the firm, perhaps based on the type of case, or it may be a particular aspect of the case that's delegated, such as tax work. IPs may use subcontractors, such as employment specialists. Also, joint appointments are very common. So a joint appointment will generally involve delegation by one of the IPs to the other, if there's two of them, and the latter, the one who's working on the case day to day, is usually called the lead IP. And sometimes the two IPs work for different firms. Despite this, the IP remains responsible for all of the work carried out on the estates over which they're appointed. So this may be described as the IP being vicariously liable, especially where the person carrying out the work is an employee of the IP, or it may be better categorised as a non-delegable duty. In the case of Woodland and Essex County Council in 2013, in delivering his judgment, Lord Sumption described the non-delegable duty as the conventional way of describing those cases in which the ordinary principle is displaced, and the duty extends beyond being careful to procuring the careful performance of work delegated to others. In that case, the Supreme Court found that the council had a non-delegable duty to a pupil who attended a school swimming lesson with an instructor who was an independent contractor for the council. The insolvency guidance paper on control of cases states that when delegation takes place, an IP must be satisfied at all times that work is being carried out in a proper and efficient manner appropriate to the case. And that paper also provides recommendations of which IPs should have regard, including procedures to ensure consultation, the circumstances in which reference should be made to the IP, and of particular note in our current situation with everyone at home, guidelines to deal with cases administered in locations which are remote from the IP. The Code of Ethics also recognises that delegation may take place, but similarly, it puts the responsibility squarely with the IP. So one of the requirements in the Code of Ethics is, although an insolvency appointment will be personal to the insolvency practitioner rather than their firm or employing organisation, insolvency practitioners shall ensure that work for which they are responsible, which is undertaken by members of the insolvency team on their behalf, is carried out in accordance with the requirements of the code. One of the reasons for delegation to junior members of staff is they normally have lower charge-out rates, and that helps the IP to ensure that best value is being provided to the estate, where remuneration is on a time cost basis. But junior members of staff will by those more senior, and that may help to provide justification for remuneration requests. So now we move on to expert evidence, and that's back to Holly.
Evidence. The duty of the court is to restrict evidence that is reasonably required to resolve the proceedings after 5.1. But in the professional negligence context, the wonderful Lady Justice Butler-Sloss reminded us in Sanson and Metcalfe and Hambleton Co. that it's clear that a court should be slow to find a professionally qualified man guilty of a breach of his duty of skill and care with a client or third party without evidence from those within the same profession of the standard expected and the facts of the case and the failure of the professionally qualified man to respect that standard. Not an absolute rule, but unless it's an obvious case, in the absence of relevant expert evidence, the claim will not be proved. Mr. Justice Coulson took this line of reasoning perhaps even further in the Pantelli Associates Limited case at the bottom of the slide there, where he suggested that not only is it expected that input will be obtained from an expert prior to pleading any allegation against the professional, that their conduct has fallen below the standard required, but also that it might actually be an abusive process if the claimant hadn't obtained that evidence when they issued, because they wouldn't properly be able to sign a statement of truth suggesting the professional's competency had fallen below expected standards without evidence from his or her peers that that was so. So as a general rule, it's sensible for professional negligence claims against IPs to be brought on the basis of an expert opinion from an independent third party, and that should be obtained before the decision is made to commence proceedings. And that's reflected in most of the well-known cases. So you've got Stanley Davis, for instance, you've got Pitt and Mond. They all had experts for both applicant and respondent. But like all good rules, there are exceptions. And the first was alluded to by Lady Justice Butler-Sloss, and that is the plain and obvious case. For instance, that might be missing a time limit. An example of that would be a case like DeMarco and Perkins. You'll recall in that case, the claimant was a bankrupt who retained the defendant firm to obtain an annulment of an IVA with his creditors. That route's obviously only open to an undischarged bankrupt, and any IVA therefore had to be established before the date of automatic discharge, which was the 26th of March 2000 in this case. Regrettably, the judge found the defendant firm had failed to realise the significance of the date, or at least hadn't warned the claimant about it, or act themselves with any degree of urgency. And that date was unfortunately missed, and the opportunity for annulment by that route was lost. The case is obviously best known for its treatment of loss and damages, because the court ended up awarding a modest sum for reputational damage as a result of remaining bankrupt, rather than the cost of securing the required annulment on a claims paid basis. But it's also an instructive example of a case where the judge had no difficulty in applying the standard of care and finding that there had been a breach because it was a plain and obvious case. Secondly, you've got the antithesis of the plain and obvious case, which is the entirely novel situation. And there, by definition, there's no evidence of the adoption of any particular practice or standard available. you're going to be able to identify this sort of case because of the difficulty that you're going to have in finding anyone who feels able to give an opinion and sign off a report on the issue that's raised. Third is the type of case that we've already touched upon, which is where a practice that is routinely followed by professionals, but is objectively unreasonable. And in a case like that, expert evidence that the objectionable practice is common isn't going to assist the court. And an example of that sort of case is the Edward Wong Finance Co. and Johnson, Stokes and Master case. The defendant's solicitors in that case handed over completion money to the vendor's solicitor in exchange for an undertaking that suitable security was going to be provided within 10 days. You can see that the writing was on the wall there, no such security in the event forthcoming. The vendor's solicitors defaulted on the undertaking. And the transaction as it was carried out was on the evidence conducted entirely in accordance with normal conveyancing practices in Hong Kong, unbelievably. But that notwithstanding, so despite the fact the expert evidence was this was common practice, the Privy Council held the risk inherent in the style of completion was foreseeable and readily avoidable, and therefore concluded that there could only be an affirmative answer as to whether the defendant firm was negligent in not foreseeing and avoiding the risk. Now, in practice, it's probably going to be quite a rare case where you feel confident enough to say for sure to a judge at the direction stage, look, you don't need expert evidence because even if this does turn out to be the common practice, it's obviously wrong. The judge might well decide that he or she wants to admit evidence in case it emerges that there is some justification for it as part of that evidence. Nothing is lost in that situation because it's still open to the court to reject the evidence. But of course, the court does have a duty to restrict expert evidence, which we just talked a moment ago, to what's reasonably required to resolve the proceedings. And so dispensing with experts saves the parties costs, saves the court time in a trial. So in my view, where you have a case where a particular common practice is inherently risky, it is worth a punt at getting the courts to dispense with hearing evidence about the practice, because ultimately what's the worst that can happen, I suppose? There's unlikely even to be a cost consequence in losing an argument about whether you need an expert, because the cost of directions hearing is almost always going to be in the case. So it could be worth doing. Fourthly, and which might most commonly be said to apply to IPs, there's no expert evidence going to be necessary where there is adequate regulation, textbook learning, or standard practitioner guidance, which the court can apply to the facts itself without the need for any expert guidance. So, for instance, expert evidence isn't likely to be needed from an accountant on the meaning and interpretation of standard accountancy documents in the Chancery Division, for example. And there's a case at the bottom of the slide there called Re-ISG Group Limited, where the court decided it didn't need an expert, for instance, to assist in the interpretation of SIP 13 in its then form. One point to remember, if you do find yourself in a situation where you are the claimant or acting for the claimant in a particular case, and you're being challenged by an experienced Chancery or ICC judge as to the need for expert evidence, where the issue at hand is whether or not the office holder has followed a provision in the Act or in the rules, take careful heed of that, because it might tend to suggest that your best case isn't really based on a traditional failure to exercise reasonable care and skill, but instead you should be focusing on ultra vires argument. So, in other words, alleging that the office holder had acted outside of their permitted powers and should be strictly liable for the consequences, rather than alleging that they've fallen below the standard of care. So, for example, in the context of distribution in an MVL, the decision in Re-AMF International Limited was one where the liquidator was essentially found strictly liable for paying a contributory ahead of creditors, which was an act that was ultra vires, not just one that fell below the normal standard of care. All of that said, the advantages of obtaining expert evidence, and in particular an advisory expert opinion from a third-party IP, are usually going to outweigh the disadvantages and will end up being a prudent investment, because even if the evidence isn't admitted by the court, the expert might remain in the shadows, and their view is still highly likely to help to inform the manner in which evidence, cross-examination and submissions are presented. A final note of caution before we move on to giving advice, and that is a subsequent office holder which is contemplating a claim against a former office holder may be tempted to think that they, as a qualified professional IP, could simply form a view themselves on the prior office holder's conduct, and that would be sufficient then for them to just articulate that view before the court in evidence. So to say, well, I'm a professional IP, I know that this person did wrong. Don't be tempted to do that. It's well established that an IP can't act on his or her own cause in adversarial litigation, and that's expressed most clearly in the case at the bottom of the slide there, previous slide, Recolt Telecom PLC. We're now going to move on to some examples of the practical application of the standard of care, and Rachel is going to kick us off with talking about when the IP is engaged to give advice. Rachel?
Thank you. So an IP will face contractual liability where they're engaged to provide insolvency advice, typically, but not always, pre-appointment. Sometimes even after appointment, an IP might get fresh instructions to advise on something like an exit solution. Where there is a formal retainer, the IP's obligations are likely to be spelt out in terms and conditions incorporated into the letter of engagement. But typically there'll also be an implied term that the retainer will be conducted with reasonable care and skill. And the same Boolean test applies to a duty of reasonable care, whatever its source, whether it be contract, tort, or statute. Remember, if an IP chooses to give professional advice and they know their expertise is being relied upon by the recipient, even without a formal engagement or any promise of remuneration, they may well be found to have assumed responsibility to the recipient for the contents of that advice. And they'll owe a cautious duty of care under the principle in Headley, Byrne and Heller to exercise reasonable skill and care in giving that advice. It's therefore really important for the IP to be clear about the capacity in which they're speaking to a debtor. Are they speaking as the office holder, in which case it's highly unlikely a duty of care will be owed, or simply as an insolvency professional, where a risk of assuming a duty is much greater. An example of a case where this arose is Prosser and Castle Sanderson. So this was a professional negligence claim brought by an individual against his former solicitor and also an IP who had previously advised him and then subsequently become the supervisor of his IVA. The allegations of negligence concerned the advice, or more accurately, the lack of advice, given to the debtor during the course of a 5-minute break taken during the creditors' meeting to consider the debtor's IVA proposals. The debtor alleged he asked his solicitor and the IP whether he had any alternative to placing the company that he also owned into immediate liquidation to meet the demands of the voting creditors in his IVA. And the judge found that the IP had either given or expressly associated himself with the advice, that there was no alternative. The debtor alleged he should have been advised to seek an adjournment of the meeting for 14 days. And at first instance, His Honour Judge Hegarty QC found that in relation to the events which occurred during the break, the IP did not owe a duty of care. But his decision was reversed by the Court of Appeal. So the Court of Appeal accepted that it should be careful not to impose duties upon nominees or chairmen of creditors' meetings when they were acting in that capacity. But it emphasised that it was important for a nominee or a chairman of a creditors' meeting to make clear to a debtor in what capacity they were acting at any particular time. Particularly, of course, like in this one where there'd been a previous advisory relationship. The IP could have given an express disclaimer about the advice that he was giving to the debtor, or even better, chosen not to have embraced the position where he was giving or endorsing advice during that adjournment. He could have stood idly by or been elsewhere. But having chosen to involve himself on the facts, it was fair, just and reasonable to impose a duty of care. Lord Justice Clark went on to say that he did not think this would pose any difficulties for nominees or chairmen of creditors' meetings. It just merely emphasised the importance of their making it clear to the debtor in what capacity they're acting at any time, which in his opinion was very desirable. The Court of Appeal actually refused to consider whether the duty had been breached because the judge hadn't made any findings on this issue, having concluded that there was no duty. So it wasn't necessary for the appeal court to make their own findings because the case would fail anyway. There was no loss because there was no chance of a better outcome for the debtor even after an adjournment. The judge had found on the balance of probabilities that the debtor would not have provided the accounting material required by his creditors in time, just as he hadn't in the months leading up to the creditors' meeting, despite pressure from his advisors. And without the accounts, there was no realistic chance of the creditors changing their mind about the proposals. So it's interesting, but obviously a completely speculative exercise to consider whether, had the judge found there was a duty, he would have found a breach in these circumstances. Yes, there was an option to adjourn, and yes, that option wasn't given to the debtor. But doesn't IP fall below the expected standard of care by failing to advise a debtor to seek an adjournment, which would in practical terms buy 14 days, but get the debtor no closer to his goal, and therefore effectively be pointless? The Court of Appeal obviously thought it wasn't a straightforward question, which is why they ducked it, as appeal courts are privileged in being able to do from time to time. As well as being careful about the capacity in which they're acting when giving advice, an IP has to be careful about the identity of the recipient. Is it the company, or is it the individual, or is it both? In Wade and Copperton and Appleby, the principal claimant, Mr. Wade, had built up an engineering business structured via a holding company and a trading company. Mr. Wade was director of both companies and the major shareholder, along with his wife. Companies encountered trading difficulties with a contractor, and 2 days before the appointment of receivers, approached the defendant firm to seek their advice, with the trying to avoid an insolvency process. That was unsuccessful, and the bank subsequently appointed the defendants as receivers. The claimants brought a negligence claim against the defendants, alleging negligent advice before their appointment as receivers. Mr. Justice David Richards, as he then was, concluded, having regard to the circumstances of the initial engagement, that a duty was owed both to the Wades personally as well as to the companies in question. The allegations of breach ultimately failed on their facts because the defendant was found to have discharged its duty of care. This was because the advice and service that the IPs were requested and required to provide did not go further than advising on the approach to the bank, preparing a letter to the bank on behalf of the holding company, and giving advice from an insolvency perspective on the offer of finance from a lender of last resort. Having regard to the very short time period involved and the limited nature of their instructions, the defendants were not able and could not have been expected to carry out an independent business review or be expected to perform any wider investigations. And there was also a causation point. It wasn't accepted that there was any realistic counterfactual prospect of additional or alternative funding being made available, which would have averted the appointment. A potentially difficult area for IPs is independent business reviews, IBRs, because the duties could end up being owed to various parties with conflicting interests, making them essentially impossible to discharge. An example of a case like this is Premier and PwC and Lloyds. The allegation of negligence against PwC related to the work that they carried out before the company entered insolvent administration. And in particular, this focused on advisory work that they gave shortly before and during an IBR process, which the firm had advised the companies to follow in order to procure support from the bank for further funding. The firm also advised on the funding need before and during the process. The question of the scope of duties owed and to whom, including potentially the bank, was found to be a triable issue of fact, although this case was settled before trial, so there's no judgment on it. One final point in advice cases is that the benefit of a contractual advisory relationship is that the parties get to agree the terms beforehand. So the IP has the opportunity to seek to control their liability. And sometimes this is attempted by the use of exclusion or limitation clauses, seeking to cap damages for any breaches in letters of engagement. These will usually be standard terms, and therefore they're subject to the reasonable test in the Unfair Contract Terms Act 1977, such that the clause must be fair and reasonable in the circumstances which were or reasonably ought to have been known to or in the contemplation of the parties at the time they entered into the contract. There are lots of factors to be considered in that balance, but perhaps one of the most persuasive is the relative abilities of the parties to meet that loss themselves or via insurance cover. IPs should have liability insurance to cover losses caused by negligent advice given in the usual course of their business. So in those circumstances, is a judge likely to say it's fair that the loss should actually fall on the client? There are also additional protections for consumers under the Consumer Rights Act 2015, which might well apply to individual debtors contemplating IVAs or bankruptcy. And the upshot is these sorts of clauses aren't automatically struck down, but they are vulnerable to challenge, and you can't always assume that they'll protect you as an IP, or if you're a solicitor, that they'll protect your IP clients. So moving on to investigations.
Yes, investigations. It is the core function of any office holder that they investigate the affairs of the company or the bankruptcy estate over which they're appointed. The latest version of SIP 2, which was, I think, introduced in April 2016, emphasises and outlines the positive investigatory duties that are owed by liquidators and administrators. It recognises that investigatory functions have to be proportionate in paragraph 4, but that irrespective of a lack of funds, there are certain key initial actions which emphasise in paragraph 9 to 11, which I'll pop on the slide there for you, and which contemplate that basic initial inquiries have to be performed in all cases. There is also a positive duty on liquidators, administrators and administrative receivers to report on the conduct of directors under section 7.3 of the Company Directors Disqualification Act 86. And that's done obviously by submission of a conduct report to the disqualification unit of the Secretary of State within 3 months of the administration, liquidation or receivership. Paragraph 19 of SIP 2 states that the office holder should base any conduct report on information coming to light in the ordinary course of their inquiries and isn't required to carry out investigations specifically for the purpose of fulfilling their statutory reporting obligations. But despite that caveat, corporate office holders may and often do, as part of their proposals, particularly in the case of administrators, confirm what steps they propose to take to investigate the affairs of the company and its officers. Now, having set out your proposals or your intentions, these are going to become a de facto benchmark for your actions. And I've actually seen a few cases where administrators have been hoisted on their own petard, as it were, because they've failed to carry out the investigatory work that they themselves contemplated they would do. And in those circumstances, it's very difficult to go back on that after the event and essentially to argue that you weren't required to do what you said you were going to. And you can imagine how the examination would be. An example of an allegation of investigatory failings on the part of administrators is a case that I was involved in with QC and Chambers relating to the administration of the Altala Group. The claimants were the liquidators, whose application for permission to bring misfeasance proceedings under paragraph 75.6 of Schedule B1 of the Insolvency Act 1986 against the former administrators was granted by Deputy Registrar Middleton back in May 2017. The principal complaint that was made against the former administrators was essentially a failure to investigate properly claims against the former directors in circumstances where they were on notice that claims needed to be made within 4 months of the administration appointment if the benefit of a 15 million directors and officers insurance cover was to be preserved. And the Deputy Registrar considered that the application had sufficient merit for permission to be granted to bring that claim, so that the threshold gateway was passed. A trustee in bankruptcy also has investigatory duties as a necessary adjunct to his positive duty to realise the bankrupt's property for the benefit of creditors. And those duties require an investigation into the available assets, including an inquiry into what assets might have been dissipated in the 5 years before the insolvency process, that being the relevant period for the purposes of TVs, and in fact potentially further back in time if a claim under section 423 is under consideration. Also any dispositions that were made after the presentation of the petition, which was prima facie void. A lot of this work is obviously done initially via the questionnaire and also follow-up interviews, but in bankruptcy it's important to remember it's not only the snapshot asset position at the date of the bankruptcy order that's important. Trustee also has an eye out during the course of the bankruptcy for things like the acquisition of after-acquired property that could be claimed, and also any increases in income for the purposes of a potential income payments order. Looking next at pre-packs will be Rachel.
So, as I'm sure you all know, pre-packs are often used to save a business, and they have the advantage of allowing any break in trade to be avoided. That can be damaging to goodwill, hence the value of the business. At the same time, pre-packs remove the need for the IP to trade the business themselves, which can have significant risks and frequently just isn't possible anyway. Pre-packs do, of course, get some bad press, especially where the sale is to a connected party. And IPs are expected to be aware of the suspicion with which pre-packs may be viewed. Accordingly, SIP 16 expects an IP to recognise the high level interest the public and the business community have in pre-packaged sales in administration. The insolvency practitioners should assume and plan for greater interest in and possible scrutiny of such sales, where the directors and or shareholders of the purchasing entity are the same as or are connected parties of the insolvent entity. According to the Insolvency Service review of pre-packs in October 2020, of the 473 pre-packs which took place in 2019, 260 of them involved a sale to a connected party. That's 55%. In efforts to increase confidence in connected party pre-pack sales, and following the reports of now Dame Theresa Graham in 2014, the pre-pack pool was introduced to provide an independent opinion on such a proposed sale. The purchaser has the option of approaching the pre-pack pool to request that one of the members of the pre-pack pool provides that opinion. The member won't actually say the pre-pack's good, but the opinion will be one of the following. Firstly, nothing is found to suggest the grounds for the proposed pre-pack are unreasonable, or evidence provided has been limited in some areas, but otherwise nothing has been found to suggest the grounds for the proposed pre-pack are unreasonable, or there's a lack of evidence to support a statement that the grounds for the proposed pre-pack are reasonable. Paragraph 9 of SIP 16 requires IPs to make any connected party considering a pre-pack purchase aware of their ability to approach the pre-pack pool. The decision on the part of the purchaser is currently voluntary and the uptake has been quite low. Of the 260 connected party sales in 2019, there were only 23 referrals to the pre-pack pool. There's been a survey of IPs asking why they thought the pre-pack pool wasn't being used more. And that found the most common reason was that the purchaser saw no benefits. The second most common reason was money. There's a fee of £950 plus VAT to get the opinion. As I'm sure you're all aware, draft regulations have now been produced by the Insolvency Service to regulate sales to connected parties during the first 8 weeks of an administration. And that would, of course, include pre-packs. The regulations would prevent such a sale taking place unless either creditors have approved it or a report has been obtained from an independent person providing a statement as to whether they're satisfied that the consideration to be provided is reasonable. Even if the consideration is not considered to be reasonable, this doesn't stop the sale going ahead, but the IP would have to provide their reasoning for proceeding with the sale. There's been some discussion around the identity of the person providing the report under these regulations. As it's currently drafted, anyone can provide the report so long as they are independent and they believe they have the requisite knowledge and experience to do so. I've seen some people suggest that their cat thinks it has the requisite knowledge and experience, so is qualified to provide a report. So there may yet be some changes to the drafting, and maybe to narrow that wording a little bit, and how the regulation final form remains to be seen. A point in pre-packs which can be contentious is the independence of the administrator. The Code of Ethics requires IPs to consider conflicts of interest in all cases, but it specifically recognises that a pre-pack sale could lead to an actual or a perceived threat to the IP's objectivity. The IP or their firm often advises the company prior to appointment, and then as administrator, the IP will have conduct of the sale and also a duty to investigate the actions of the company's directors. So this was the case in V Interactive, as on the slide there. Creditors requested removal of the administrators on the basis that investigations were required as to any breaches of duty by the administrator's firm or by the directors. And the administrators were unable to carry out this task due to their conflict of interest. So the Code of Ethics would class that as a self-review threat. The judge agreed that the administrators ought to have concluded from the date of their appointment or soon thereafter that they were conflicted and couldn't carry out these investigations. And it seems in this case that the administrators realised the problem during the trial and they gave notice of their intention to resign. But the judge decided it was appropriate to remove the administrators and appoint replacements without waiting for that resignation to take effect. So I will now move on to sales. So a classic situation for a claim against an IP relates to sales, in particular transactions involving asset realizations, where it's alleged the asset was sold at an undervalue. When disposing of assets, an office holder will have to achieve the best price reasonably obtainable, and that duty is analogous to the duty owed by a mortgagee to the mortgagor. One of the first reported cases in the field of professional negligence claims against IPs is re Charlie Davis. So that's an example of a transaction case. Also one of the most recently reported cases in Davian Money. So both of those cases were misfeasance administrators. But similar claims may be made against liquidators. It should be noted that in Davian Money, Mr. Justice Snowden rejected the notion that an administrator owes the more onerous duties of a trustee selling a property. Instead, their duty when acting as agents to sell the assets of a company in administration is simply to take reasonable care to obtain the best price which the circumstances of the case permit. So the relevant standard of care is that of an ordinary skilled practitioner. Both the claims in Charlie Davis and Davian Money failed on the facts, but in practice, it's not always easy to ensure that the duty has been discharged. The assets in question may be of uncertain or diminishing value. An administrator or liquidator might not have had the time or the resources to trade the business or engage in an extended period of marketing. But it's still important to distinguish between errors which constitute negligence and what may be described as errors of commercial judgment, where there's a greater latitude allowed for. So with that in mind, we've tried to come up with a list of risk areas or warning flags which might give rise to liability concerns, and we'll set out these on the slides. So a failure to investigate fully the extent and nature of the assets to be sold could be a warning sign. Liability could also arise if the IP fails to consider whether assets may be worth more individually rather than being sold as a portfolio. Failure to identify any obvious potential to add value. So, for example, where a complaint might be made that no account was taken of the fact that the property had planning permission for development, as was the case in Cook and the Brick. Another risk area could be where there's a potential special purchaser identified. So that was the case in Devon Commercial Property. And in that case, there was a special purchaser who was the occupier and also the appointer. Next, a failure to take independent expert valuation advice is a key red flag. So that advice really helps safeguard the IP from risk, and it's usually easily obtained in respect of things like real property, plant machinery values. There may be more difficulties in respect of intellectual property or intangible assets, where there may not be an obvious market, so those assets can be quite difficult to value. And failure to instruct the right kind of expert is also a risk area, as was the case in Brewer and Iqbal. A further potential risk area may be, even if the right type of expert is instructed, in whether or not the instruction has been provided on the correct basis. So that can occur where there's a particular market or a purchaser which the IP knows or ought to have known of, but it doesn't form part of the instructions to the expert valuer. So in Devon Commercial Property, the complaint was made that marketing wasn't performed or targeted at drinks companies. Another potential flag is either excessive haste or undue delay in taking realisation steps, and that can have a depressive effect on value. Overlapping, but a key risk area, is failure to properly market the property or expose it to the marketplace. And public advertisement is the norm, especially outside the pre-packed scenario or often in it. As in Fisher and Lightwood, whatever the mode of sale, it should be properly advertised. But on the appropriate facts, the court may absolve an IP from exposing property to the open market as happened on the facts in Davian Money. And lastly, many deals involve an element of deferred consideration. And an IP may be under a duty to secure the benefits of that deferred consideration in case of default. If the purchaser is a new company or is otherwise unable to give adequate security, then personal or parent company guarantees should also be considered. So moving on to the case of a trustee in bankruptcy, and the guiding principles for trustee vendors were summarised in Killearn and Killearn. So firstly, to sell under every possible advantage to the beneficiaries. Secondly, to secure a proper competition to obtain the best price for trust property. Thirdly, to investigate higher offers, even at a late stage where an ordinary vendor might feel a bit embarrassed to change horses. And fourthly, not to advance the interest of one party at the expense of another. Lastly, in exercising a power, the burden of proof is on the trustee to show that they exercise that power properly. An example of a case on strong facts where liability was established against a trustee was McAteer and Lismore. So the defendant was the trustee in bankruptcy over the estate of the late Mr. McAteer from April 1995. In the discharge of his duties, the trustee obtained possession of and sold the former matrimonial home. Mrs. McAteer contended that the sale had been at an undervalue, and the trustee was in breach of the duty of care owed to the estate of her late husband. So in the judgment of Mr. Justice Deeney, this complaint was well founded, principally on the basis that the property had not been marketed or advertised for nearly 5 years before March 2005, when it was sold, so almost 10 years later. Obviously, that sort of thing is much more unlikely to happen now with our 3-year use it or lose it rule. So we are now on to litigation, Holly.
Yes, and I have cunningly avoided the problem of miming to you all by not turning off my microphone during Rachel's part there. And I'm going to talk to you about our last specific area, which is commencing and conducting litigation. A common complaint is the failure to commence litigation, which is particularly irretrievable, obviously, when limitation passes in the meantime. This is an instance of what we would call non-feasance rather than misfeasance, which means a culpable failure or omission to act rather than a negligent act. But it makes no difference in these circumstances. From a standard of care perspective, these sorts of claims can be relatively straightforward. It's going to be difficult to resist the conclusion that allowing limitation to pass on your watch is negligent. But there might be circumstances that mean a reasonable IP acting with due care and skill couldn't have discovered the claim in time, for instance. Another defence would be to argue that prospects or perhaps the funding position were such that issuing the claim wasn't justified. Obviously, if you as a lawyer or as an IP are going to run that argument, you're going to need a lot of file notes showing all of your working and also the legal advice obtained. Most of the case law on lost litigation claims are claims against solicitors. That's a completely different ballgame from similar claims against IPs, because solicitors act on their client's instructions. If a client can establish on the balance of probabilities that properly advised they would have brought a claim within limitation, they can claim for their lost chance of success in that litigation. Because it's a loss of a chance claim, the claimant doesn't have to prove on the balance of probabilities the claim would have been successful, and the court doesn't hold a trial within a trial. All the claimant has to do is establish the claim has a real and substantial chance of success in order to be able to claim compensation specifically referable to that lost chance. In some cases, the court's interpreted a real and substantial chance of success to mean a chance of 10% or greater, although there's no set rule. So this leads to the slightly anomalous position that a client can recover 49% of their damages from their solicitor for failing to issue a case which, on the balance of probabilities, they would have lost at trial and got nothing. And conversely, they might only get 51% of their damages for a case which they would have won at trial and been awarded full damages for, had they not been provided opportunity by their solicitors, where the merits were considered to be 51% by the court. But an IP, unlike a solicitor, obviously has to make their own decision about whether to bring a claim, just acting on the client's instructions. And that decision is going to be based in part upon the claim's prospect. So unless the claim is itself a loss of a chance claim, in which case you can argue about whether or not the chance provides risk of litigation. In a normal claim, decided on the balance of probabilities, you can see that it would be difficult to criticise an IP for failing to issue where prospects are reasonably assessed at less than 50%. It would be really tough to prove a breach in those circumstances. But more fruitful would be an allegation that the IP failed to assign the claim if an offer was made, and the putative assignee has therefore lost the chance of success, even a small chance, as a result of that decision. Still on the subject of time limits, a similar type of failing might be said to arise in the personal insolvency context, where a trustee fails to take action in relation to a bankrupt's home before it ceases to form part of the estate under the use it or lose it provisions in section 283A of the Act, such that it revests in the bankrupt. A reasonable amount of comfort can be sought in taking and following legal advice in relation to the commencement and the conduct of litigation, but we've already touched upon the fact that this isn't completely safe harbour. It's not bulletproof, because the IP will have to show that they gave full and proper instructions on the basis of proper investigation. It was His Honour Judge Simon Barker in Top Brands and Sharma that said, a liquidator will not have taken proper advice where the instructions to the advisor were flawed, partial or incorrect, by reason of a failure on the part of the liquidator to identify relevant considerations, or a failure to use all proper care and diligence in obtaining information relevant to the instructions given, or a failure to use all proper care and diligence in obtaining information relevant to the advice obtained. We've also touched already upon the IP's liability to seek directions from the court, and in particular, that was drawn out of Mr. Justice Malm's speech in the 1930s case, Rehome and Colonial Insurance Company, often relied on for that proposition that IPs can seek directions. But these days, this decision probably does need to be taken with a bit of a pinch of salt, because the trend of more modern authority has definitely been to hold that the ability to apply to court for directions doesn't absolve an office holder of the requirement to actually take difficult decisions that might arise out of an inherent to their appointment themselves, such as is dependent upon a developing area of jurisprudence. And that's how the court in Parker distinguished the case of Day and Hayne at the bottom of the slide there, in which the liquidator did successfully apply to the court for directions on whether entitlements to remuneration under the protective awards made by the Employment Tribunal under Section 189 of the Trade Union and Labour Relations Consolidation Act 2022 were in fact provable debts. The corollary of that, I guess, is that the theoretical ability of the office holder to make an application for directions shouldn't be overstated these days in considering the standard of care. So there are lots and lots of other potential areas where standard of care is important, that form part of the daily diet of an IP's life and job and work. But in order to see any of the others, you're going to have to buy the book, I'm afraid. So that concludes our talk this morning. We've got a little bit of run over, unfortunately, apologies, for which I think the technical difficulties were partly responsible. But if anybody does want to stay and ask some questions in the chat function, you'd be very, very welcome to. Or alternatively, if you have to get away, do please feel free to send an email to myself or Rachel if you thought of anything, any comments or questions that you want to make afterwards. I think all that remains is for us to say Happy Christmas, however you'll be spending it. Have a lovely December, and we'll see you in the new year.
Thanks, everyone.
Thanks, everybody.